tuned in to The Andrew Lawton Show.
But I first want to talk about something that should be able to unite us all, which is our hatred of dissolving paper straws. I know the plastics ban is something that the federal court ruled was unconstitutional, but the Liberal government is still defending it. And in fact, this very week, the Liberals are defending it in the Federal Court of Appeal. Intervening on the anti-ban side of the equation is Christine Van Geyn's group, the Canadian Constitution Foundation, where she is the litigation director, and she joins us now. Christine, always good to talk to you. Thanks for coming on today.
Thanks for having me on, Andrew. It's
now, I mean, I'm just against like the ban on principle because I despise the stupid paper straws. You're actually taking an argument that is far more rooted in the Constitution than just, Your Honor, the paper straws are crap. So what's the argument here?
Yeah, I mean, so the case is about plastics. It's about this federal plastics ban. It's an organization. I don't feel especially strongly about the issue. I mean, I like sea turtles. I don't like paper straws. But what bothered me about this federal plastics ban isn't just that it isn't really the paper straws. It's a much bigger issue. It's that the federal government, the Trudeau government, seems obsessed with trying to overregulate the lives of Canadians by meddling in provinces' businesses, contrary to our constitutional division of powers. And we've seen this happen before. The Impact Assessment Act reference was all about this. But basically what happened in this case was the federal cabinet, by way of regulation, so there was no debate in Parliament about this, they deemed every single plastic product, from safety helmets for construction site workers to life jackets to pipes to plastic straws and stir sticks, every single one of them has been deemed toxic under a federal cabinet order. And I think a lot of Canadians would be surprised to learn that this was done through Parliament's power to regulate the criminal law. So they signed this order claiming that this is under their criminal law authority. The problem is that is not how the federal criminal law authority works. You don't just say something is under criminal law, under federal criminal law power, and suddenly that it's like an incantation and you say those words and it makes it so. It's not like bibbity bobbity plastic ban. It doesn't make it so. So they actually need to show that it would be an actually dangerous substance, which of course plastics, which are ubiquitous in our society, are not. There are varying levels of potential harm and potential safety. So it was overly broad.
I spoke about this a few weeks back with a plastics expert who he was approaching this from the science perspective, which is that calling plastics toxic is in and of itself incredibly wrong. And he, had a litany of evidence and research and studies he showed. The reality is we wrap medical products in plastic. We make medical products out of plastic. We eat and drink with plastic and out of plastic. So if this was all toxic, that is probably going to spell a much greater problem here. I'm curious in this case how much of that argument is relevant, or is this strictly an up and down constitutional question of is this a criminal matter?
No, so that was a big part of it. It's just not what our particular interest is.
You're an intervener in the case, just for context. You're not the litigant.
So the first day of the hearing, the federal government spent a lot of time describing the potential harms from plastics, and there were some environmental regulators like Animal Justice and Eco Justice who talked about the hypotheticals about animals being, frankly, they're not hypotheticals. The ring carriers that can harm birds and things like that. The problem is it's this wildly expansive argument to say that every single plastic item has the same level of potential danger, and therefore they are all toxic. I mean, the counsel for the Plastics Coalition who brought this challenge, she talked about how she wears contact lenses, and these are quite different in nature from a plastic straw. And with the government, if they want to regulate some specific harm, for example, this issue that people are always bringing up of the plastic straws being stuck in sea turtles' noses, that it's actually more about the shape and the the way the plastic straws are disposed of than it is about the fact that they're made of plastic.
Yeah,
So
like a metal straw that would be reusable that, got lodged in a sea turtle, I imagine would be just as
exactly.
bad, if not worse. Yeah.
Yeah. So, I mean, what they need to do is actually show that there is potential harm. There's some level of harm that could justify putting plastics as an entire category of items onto the list of toxic substances. And we argued that it's just wildly expansive, that you can't just say something is harmful. You need to actually have some evidence that it's harmful, and that this expansive approach is inappropriate, and it's an abuse of the federal government's criminal law power.
I remember with the carbon tax case that you were involved in with another organization, you had some interveners that were really trying to push the emergency angle, say the federal government can act on climate policy because it's an emergency. Are we hearing any of that in the plastics case?
No, that it wasn't on those grounds.
That's good. But the problem is a lot of environmental policy, it tends to be, defended on, I think, some grounds that are just absolutely absurd. And here you have a government that's just being very ideological about it. And as you know, they're just trying to will this constitutional basis and authority into reality when there doesn't seem to be a basis for it.
Yeah, I think what we need to think about is when the framers of our original Constitution in the 1860s decided that they were going to give the federal government and not the provinces control of criminal law, it was premised on the idea that Parliament would be using that authority to prevent actual harm, not just meddling in the day-to-day lives of Canadians. And when the government overreaches like this, when the federal government overreaches like this, they are what lawyers call ultra vires. It's outside of the scope of their authority, and that makes it the use of the power in this way unconstitutional. That's why the lower court struck down this plastics ban as unconstitutional. There was not evidence that these products are harmful as an entire category, and while there is a stay in place. So I think that we need to think about the broader problems, the bigger threat of allowing the federal government to overreach this way, because Canadian federalism is a genius, brilliant innovation. It prevents the concentration of power within any single institution or level of government. And it creates these sort of laboratories of democracy across Canada where different jurisdictions can tailor different policy solutions and figure out what works best. And waste management has been under the scope of authority of provincial and municipal jurisdictions. And some provinces, some municipalities have decided to take one approach to plastics regulation or plastic recycling or waste management. And other provinces have taken different approaches. It's not for the federal government to come in then and use a sweeping authority to claim their ability to regulate every single type of plastic imaginable under the claim that it's a criminal law issue.
I'm always curious in why people advocate against their own self-interest and their own autonomy. And in this, I'm looking at British Columbia, which as a province has said, regardless of what happens with this case, they're going to continue to regulate things at the provincial level. They've got the right to do that. Yet they're in this case defending Ottawa's right. Like, why are they as a province not seeing the concerns with this? Imagine if perhaps a conservative government that is more hostile to the agenda of the BC NDP government comes in and wants to trample into jurisdiction in a different direction.
I mean, sometimes people intervene or make arguments on an outcome-based approach. They just like a particular outcome. It's really difficult to take a position like we do at the Canadian Constitution Foundation, where you need to think about the big picture and not just your immediate self-interest. So yes, British Columbia typically sides with more stringent environmental regulation. So if they're looking at it at an outcome-based approach, then that's why they would argue this. But it isn't looking at the big picture. And I think if you think about this issue from the big picture perspective, there's all kinds of things that the federal government may use to or will try to claim are under the federal criminal law power in order to, sweep in their ability to regulate. So it's widely assumed that Canada is going to uphold oil and gas emissions caps and the clean electricity regulation, which are both currently in draft form, through the criminal law power under the Canadian Environmental Protection Act. There's concern that the federal government would try to regulate things like the electricity market or technology options using the criminal law power. And Ottawa would essentially, in this regard, become master of all environmental policy in our country. And when you think about it in a big picture like that, that may not be in British Columbia's best interest, even though siding with the federal government in this particular case may get them the outcome that they prefer.
Well, we'll certainly keep an eye out for this. I know the wheels of justice tend to move quite slowly. Do you anticipate when a decision will be made, keeping in mind it could very well go to the Supreme Court beyond that?
Yeah, so typically we say in appeals, we expect a decision within 6 months. Sometimes it's sooner, sometimes it's longer. So that's the only guidance I can give you.
Yeah, it'll come when it comes is basically the the less polished answer there. Christine Van Geyn, litigation director for the Canadian Constitution Foundation. Keep up the great work, and thanks for coming on today.
Always a pleasure, Andrew.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.